Hi, I'm David Myers, and I'm a lawyer that represents parents and children in dependency proceedings.
My name is Tracy Lee. I'm with County Counsel's Office and represent the Child Welfare Agency in the Juvenile Court.
My name is Jennifer McLaren, and I'm also with the Office of County Counsel, and I also represent the Child Welfare Agency in dependency proceedings.
And if you're being forced to watch this, it's because you are about to go to court for a selection and implementation hearing or a 2-6 hearing, or maybe it's your first post-permanency hearing, and in either case, you want the court to adopt your recommended findings and orders. This video will help explain what goes on in and around these hearings and will help you get to where you want to go. By this phase of the dependency case, there have been a lot of battles that have been fought and lost by the parents. For those of you who just inherit a case at this point, you already know that so much has happened and you're walking into what I would call a well-told narrative. This doesn't change your mandates, though, and it's important to remember that the family won't understand why you're doing what you're doing, but the court will. So let's start with some of the preliminaries.
So one of the most important things for a 2-6 hearing is that notice has been done and that it's been done properly. If notice has not been done correctly, it can create lengthy delays because the case and the hearing will have to be continued to effectuate notice. There are also certain presumptions at this stage of the proceedings. There's caregiver preferences. If a child has been in the care of a foster parent, they have they are titled what is called a prospective adoptive parent. And the assumption is that they are going to adopt the child if parental rights are terminated. Likewise, at this phase of the proceedings, we are not looking at returning the children to the parents. If that's going to happen, the parent needs to take initiative and file a motion pursuant to Welfare and Institution Code Section 388. But absent that motion being filed, we are not looking at return. We're looking at permanency for the children. Parents' counsel and sometimes minors' counsel will start to posture to try to not have parental rights terminated. And they might do this by requesting a court order for a bonding or an attachment study, or they will look to other exceptions in the code section to prevent the termination of parental rights.
That's right, and before you go to court, of course, all of these things need to be in place, as well as the report itself. Can you talk a little bit about the report and how that will help the court?
Sure. So what's the secret to writing an effective 366.26 report? As in any other review report, the 2-6 report, look to your recommended findings and orders. What is it that you're going to ask the court to do? And then make sure you have that evidence, that information is presented in a clear, concise way in your written report for the court and the parties in the courtroom.
Along with the law, the courts really look at the burden of proof, and at a termination of parental rights hearing, it's a high burden.
In order to terminate the parental rights, the court has to make that assessment pursuant to clear and convincing evidence. So it has to be, it's more than preponderance of the evidence, but it's less than beyond a reasonable doubt. The only time you will find beyond a reasonable doubt as your burden of proof is if you are attempting to terminate the parental rights of an Indian child and you are following the mandates of the Indian Child Welfare Act.
And so let's talk a little bit about what actually happens in court. What's the flow chart at a termination of parental rights hearing?
Right, so the first thing the court has to find by clear and convincing evidence is that the child is adoptable. And they can be either generally adoptable or they can be specifically adoptable. If that finding is made, then the burden then shifts to the parents, and then they have to prove that an exception applies. And so that falls on them. If you do have a child who is Indian and the Indian Child Welfare Act applies, there's certain other legal ramifications that are involved. The court has to inquire whether a tribal customary adoption is appropriate. The court also has to hear expert witness testimony from a qualified Indian expert who can testify to the ICWA and the requirements. And then again, the burden of proof is beyond a reasonable doubt, not clear and convincing.
So what does the court actually do, Trace?
The court in a 366.26 hearing is required to look for the permanency of the children and what is the most permanent plan for that child. Obviously, adoption is the most permanent plan. Guardianship, planned permanent living arrangement. And the court's going to look at your report and your recommendations to determine whether that evidence supports what you're recommending. What is the current placement of the children, and how does that meet the needs and the permanency goals of that child? What relevant evidence comes into play here. All relevant evidence comes in and must be provided in your report so that the court can make the appropriate decisions. In conducting the hearing, termination of parental rights hearings are almost always contested. And the reason being, the parent has nothing to lose at this point. Testimony is very limited in scope. There are only certain issues that are before the court, but usually the parent will testify in a termination of parental rights hearing.
And you have to remember that these things are often more emotionally difficult than legally difficult. It's a very difficult thing to do to terminate parental rights, but not because the law makes it hard, because it just is a very emotional moment. And so the more attention to detail that you are able to provide, the faster this will go, the easier this will be. There is always an appeal process as well. And the more, again, the better your record is, which your lawyer will help you with, the faster that appeal can be processed. If parental rights are not terminated and reunification ends, there are other mandated hearings every 6 months. Tracy, can you talk a little bit about what we call post-permanency reviews?
I sure can, and actually I'm going to make a little correction, because actually even if parental rights are terminated, you still have a 366.3 hearing until that adoption finalizes. So really that's post-permanency. There's been a permanent plan determined. It could be guardianship with dependency, it could be planned permanent living arrangement, and it could be adoption until that adoption finalizes. So the court keeps monitoring and moving that child forward to the most permanent plan for that child. The focus in the post-permanency hearings shifts to that of the well-being of the child. The goal, as I just said, is to achieve a permanent plan. We don't want kids in the system graduating out of the system. The role of child's counsel increases, and the court's role decreases as decisions become less legal and really looking at the well-being of that child and trying to find a family.
And the code really talks about what has to happen at those hearings. So if you are coming up to one, make sure that you look at the code, and as always, consult with your lawyer. I want to talk a little bit about non-minor dependents too. Can you tell them what exactly a non-minor dependent is, and then we'll talk about the court hearings?
So a non-minor dependent is basically a youth who was previously a dependent who turned 18. And they have the right to voluntarily participate in continued dependency proceedings and get benefits and services from the department and money, actually. They get assistance with housing, with education, and they do have to fit the criteria to participate as a non-minor dependent. But it's entirely voluntary because, as I said, they're 18, so they're adults. So they get to make their own decisions about their own life.
Yeah, and the law shifts dramatically. So if you are a social worker going to court with a non-minor dependent, the role of the hearing is very different. The court hearing will look differently. It's much more informal because we're not talking about parental rights or return. We're talking about assisting this young adult into his transition or her transition into adulthood. So the court will take a different role, the non-minor dependent's attorney will take a very different role, and your job gets a lot harder. Because this population is a very difficult population to represent because they are discovering all kinds of wonders as an adult coming from the background that they have come to. So they can be very frustrating. It's a frustrating population to represent, and it's a frustrating population to serve. And of course, the rewards can be equally as great. But the court hearings are very different, and they're very informal. So you will be asked questions much more directly by the judicial officers, and you will have a much more active role with the non-minor dependent in and out of the court. We hope this gives you a very pleasant experience with your 2-6 hearings and your post-permanency hearings, and thank you for watching.